Most of you probably already know about Standpoint, but for those that listen to this later and for those who don't know, Standpoint is a statewide organization. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors. We do this by facilitating trainings and answering calls to our action line. Examples of trainings we do are our annual new laws training that we do throughout the state and virtually, monthly webinars for advocates, and other trainings by request. Our action line is answered Monday through Friday from 9 a.m. to 4 p.m., and it is through our action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources, safety plan, listen, and help callers identify possible options and next steps. Our webinar today is Gun Laws 101, State and Federal Firearms Restrictions, ERPOs, and more. Joe is a shareholder with Eckberg Lammers and an attorney in their municipal practice area and serves as one of our lead criminal prosecutors. He focuses his practice in criminal prosecution for the cities of Blaine, Ramsey, Woodbury, East Bethel, and Oak Park Heights. From charges and arraignment to trial, verdict, and sentencing, along with contested evidentiary hearings and probation violations, he regularly handles all facets of misdemeanor prosecution for the cities they serve. And I will pass it over to you now, Joe.
And also, Ellie, you're supposed to say, we used to work together. You were
We
supposed
did
to
use
put
to
that
work
in there.
together.
And I assume I can't see anybody, so the audience participation is going to go way down. So it's always nice to see faces. But if you have questions, please do get them in. We'll make time. I will not lie as a lawyer and say that I'm going to be done early. I will try to leave plenty of time for questions. But I am happy to come talk to you all. And like Ellie said, being a part of Standpoint. If you're not familiar with the work we do, if you're not familiar, you obviously are, but using them as resources, there's a lot of good work that they do. So make sure you tell your friends about all the work they do, and certainly reach out to me if you have questions. As Ellie said, I'm a city prosecutor. I do a lot of criminal prosecution statewide. I also have found myself doing a lot of training on firearms and ERPOs, otherwise known as ERPOs, otherwise known as red flag laws. This is dangerous persons firearms confiscation and restriction laws that is now in effect in Minnesota. So as you can imagine, there's a big intersection in what you do as domestic violence advocates. So I think it's a great opportunity to talk a little bit about what these orders are, talk about what they're not, talk about why it might be important for you all to know what they are, and then give you some examples and tips. So without further ado, what we're going to cover is firearms prohibitions and ERPOs. So when I talk about firearms prohibitions, I'm talking about state and federal laws that, when applied to certain persons with certain situations, criminal histories, things like that, they are prohibited from possessing a gun. And an ERPO, an extreme risk protection order, which is actually an affirmative law that goes forward and actually removes a physical gun from someone's possession. We'll talk about specifics on the statutes. As a lawyer, it's my job to know the statutes. I know if you're not a lawyer, you may say, I don't need to know the statutes. And I say, that's nonsense. We should all know the law. So that's part of it. Get to know these laws, get to know the specifics and how they operate. I'll give you some case studies and tips. And let's get right to it. Firearms prohibitions. See, Ellie, this is the problem. I want to have people raising their hand and giving answers. We should do this in person.
You certainly do it in person.
Let's do an in-person one. It'll just be you and I talking then. Why is knowing gun laws relevant for domestic violence advocates? You may look and say, hey, prosecutor, hey, attorney, that's your job to know. And it is our job to know. And the sad thing, as you'll see in the next couple of bullet points that are going to pop up, is that there's a lot of attorneys that don't know these laws. For better or worse, as scary as that is, there's a lot that don't know which laws trigger which prohibitions, how they operate, how to make sure some dangerous person does not have access to a dangerous weapon. Those are really important things to know. The first reason why is it important is because who has information about weapons in the home? This is the part where you're all raising your hand and saying, victims give this information to you. They say, hey, he's done this X amount of times. And yeah, he has access to guns. Law enforcement gets this information in the lethality assessment screens. That's how important it is to get that information about who's got a dangerous weapon in their house. It's put in the lethality assessment screens. Does he have access to a firearm? Has he ever threatened you with violence? Things like that. Those are really important things to think about when we talk about who's a dangerous person and who's not, and whether they have access to weapons. Safety planning and safe case outcomes. That's one, right? If you have a case that you're working and you know that that person in the past has said so and so has a gun in my house, that's a really good detail to know when we think about how is this person going to be kept safe. Uh, cynical hat on. Can we do a poll, Ellie? We can't do a poll.
Yes, I
We would
think so. So I just
really?
made you
Oh my God.
co-host.
Could we make it a poll?
Let's see.
Show poll. You guys are going to get to interact after
Yes.
all.
And people can raise their hand. That's something they can select, and we can click to allow them to talk.
Okay. Am I still sharing my screen?
Yes.
Okay. Got it. Uh, Let me go back to my PowerPoint here. All right. Well, sorry, a little A side there. I was going to ask people if they think their prosecutors always know the laws. Do they always know the gun laws, but do they always know the information that you know? My experience as a prosecutor is I've been fortunate enough to work in an office that has victim witness advocate, or excuse me, coordinators, not advocates, but someone who works a little bit adjacent to what advocates do. And so I get a lot of the same information that the advocates are getting, which I think is a very good thing. But what I don't always get is I don't always get the details that you might get, and other prosecutors might not always get that information. Oh, there's Amanda. That's perfect. Um, yeah, that's I appreciate that comment because that's definitely what I'm getting at is I don't think all prosecutors always know exactly the laws related to firearms, and not all of them have staff that are helping get that information. And I wish this wasn't true, but unfortunately, I think there's a lot of prosecutors who view domestic advocates as not necessarily on the same team, which is unfortunate because I know the good work that you guys do. So that's a really good reason for a domestic violence advocate to know the law, to know some of the things that intersect with the work that you're all doing. And so, um, we're still frozen. There we go. Collateral consequences of pleas and convictions. This is one why it's important because sometimes you are involved, at least tangentially, in the negotiations because you're relaying information to a victim about a proposed plea. And if there are gun concerns involved in that plea, the collateral consequences of what the plea is to, what the conditions of probation are, is really important. And so again, I'll ask, do prosecutors always know? I worry that there's not enough prosecutors that know all the collateral consequences on a domestic violence case, on a domestic violence plea, as it relates to firearms possession and eligibility. Those are really key things to know. So ultimately, why is it important for a DV advocate to know this stuff? Because you may be the person, the only person in the room who's paying attention to that, which is really sad and cynical, but unfortunately true in some cases. So let's talk big picture. Domestic violence related crimes as it relates to state and federal law prohibition authority. I'm going to try to boil this down into why I think you need to know both the state law and the federal law. One of the things that people often talk to me, law enforcement in particular, is they say, well, the law is so confusing. Federal law says this, state law says that. How do you know what to do? And what I will say is, as a lawyer who started seeing this gap of knowledge in law enforcement and lawyers and started working toward teaching myself it and practicing it so that I could help others learn it, I will say it's not actually inconsistent laws. They're just differently written. And so they seem confusing, but you have to spend some time to get to know them. And I say that only because knowing which prohibition is in play will be really important when you're having those conversations with, well, a plea to this charge might trigger a federal ban, and a plea to this charge might trigger only a state ban. That might be helpful to know because it will indicate where it will help dictate and determine which plea is a better one in terms of safe outcomes related to firearms authorities or prohibition. I will also tell you, big picture, if we zoom out a little bit, there are the reason these laws are in place and how they operate is Minnesota is what's known as a permit to purchase state. Not every state requires people to apply with a local law enforcement agency to get a permit to buy a gun. Minnesota is one of those. That presents the first barrier towards someone getting a gun. So you have to fill out an application, you have to submit to a background check, you have to give all the details that they needed, and then the chief has to conduct certain background checks. So, do you have certain criminal convictions? Have you been civilly committed? All these things that go into it. And then if they pass, they get their permit to purchase. They can then go buy a gun. Now, to carry that gun, they'd also have to get a permit to carry. But if you have one, essentially it operates like the other. So there's kind of that initial check. Domestic violence related crimes, and when I talk about prohibitions, this is where it comes into effect, which is again why it's really important for prosecutors and city attorneys to know this stuff, because they're the ones that are going to give law enforcement advice. When law enforcement says, hey, John Jackass has this kind of conviction on his record. Hey, Ellie, sorry, can I swear? She say, I'm on the board of standpoint, so I'm going to rule that I can swear.
Yeah, I
Sorry.
think you can swear.
It's just gonna rule. All right. Um, they're the ones that they're giving the advice when somebody like John Jackass comes in. He's got this conviction. What do I do? If the prosecutor doesn't know the law, I've seen it happen. People think they're reading the right law, but they don't know that there's also a federal piece to it, or vice versa. And so they end up giving the wrong advice. And then somebody who's ineligible now has a gun. Really scary outcome. So these prohibitions, these laws, state and federal, are the first part of that background check piece to make sure people who are not prohibited by law from getting guns don't get guns. That's what this first piece is. So, talking specifically about domestic violence related crimes, 18 USC 922G says it shall be unlawful for any person convicted of a misdemeanor crime of domestic violence to possess, sell, transport, ship, etc. Can't do it if you have been convicted of a misdemeanor crime of domestic violence. Now, this is the part where I usually ask the audience to tell me what they believe a misdemeanor crime of domestic violence is, and everyone says domestic assault, and then the weirdos from Wisconsin say battery, and we're like, we don't have battery. I will tell you it's different at the federal level than it is at the state level. At the state level, a misdemeanor crime of domestic violence could look like a number of things, but we look under the federal law, what the federal government says it is, what federal statute says. It says it's a misdemeanor under any state, federal, or tribal law. The crime has to be a misdemeanor. And in that crime, it has to have an element of the use or attempted use of physical force or the threatened use of a weapon. Has to have that in there. It has to be committed by a current, former spouse, parent, guardian, lived with as a current, former spouse, guardian, etc., dating, former dating relationship. Does that sound familiar? That third one? Who are we talking about? Essentially, there's some differences, but generally we are talking about family or household members defined under 518B, right? So, to think through at the state level, you may have a criminal conviction for domestic abuse, and you may say, got it, that's a state and federal prohibition. And me, Professor Van Thomme, would say, well, hold on, you probably have it at the state level, but as far as a lifetime ban, which is what a federal misdemeanor crime of domestic violence is, you'd have to go through and apply each one of these elements. So a domestic assault crime, if it's a misdemeanor, and that crime involved attempted use of physical force or threatened use of a deadly weapon, and it's against the right person in that relationship definition, then it is a federal ban. Lifetime ban. Done. So, really important to know those three elements, because as we'll see in a few minutes, it gets a little, when you go to court and you have a prosecutor who works out a deal, some sort of plea, does that still trigger a state or federal firearms ban? It'll be really important to know those details. One of the last pieces about that relationship, who the crime is against. Misdemeanor crime and domestic violence, the dating relationship factors. It's all of those things that we talked about before. We talked about parent, guardian, spouse, etc. But then also dating relationship factors. You may look, and this is what's known as the boyfriend loophole, because there was a time where that relationship wasn't connecting everybody, wasn't catching the boyfriends, the live-in boyfriends, things like that. So you look and say, well, does it meet the federal standard for the type of relationship? You look at how long have they been together. You looked at what type of a relationship is it? Is it an on again, off again? Is it a consistent? Are they holding themselves out as boyfriend or girlfriend? Um, Frequency and the type of interaction involved with those individuals. Those are all the things that you're going to look at to decide, is this the type of relationship that if there's a crime committed by one against the other involving force against that person, qualifies for a federal ban if there's a conviction. So misdemeanor crimes of domestic violence, which Minnesota laws qualify? Any hands? Is there any? I wouldn't even know if they were saying anything. Um, Ellie, I'm gonna assume everyone's just going crazy on the other side, raising hands with good ideas. So I'll just assume. Do Minnesota laws qualify? It always pauses on me. There you go. Number one, do you have a misdemeanor conviction? Yes or no? Those are easy to tell, right? We all know what that sounds like, looks like. Number two, does it involve force? So number of crimes not related to domestic assault could involve force. Number three, was the force used against the partner in a required relationship? The required relationship meaning that defined that relationship ban that we just talked about. Is it one of those people? Did it involve force? Was it a misdemeanor? Then it might be a misdemeanor crime of domestic violence. And this gives me a little bit of hope when you have cases that fall apart or you have pleas that are taken to maybe something that's not domestic violence in name. You may say, well, it was charged as a domestic, but there was a conviction for something else, and I've got all three of these things. So at least this person is banned for life from possessing guns. So I'll give you this list. It is not exhaustive. It's just ones that I've seen apply, ones that I've actually litigated, Minnesota crimes that might be. And I say might. I say might because when I teach prosecution at the law schools, one of the things I always do, it's a first day trick question. I say, hey, what's the source of law in America? And they all kind of look around, and these like egghead law students are all thinking they're going to know this. They're like, the Constitution. I'm like, right. What else? They're like, the laws. Right. What else? And they're like, what else? That's it. And then I tell them the law in the United States is what the Constitution, the laws say, and what any given district court judge on a bench and anywhere in America says. That's the reality. So I say might be Minnesota crimes that might be a misdemeanor crime of domestic violence. Obviously, is going to depend on whether your judge agrees. Um, it could be domestic assault harm, depending on the victim relationship. It could be disorderly conduct, brawling, or fighting, depending on the victim relationship. It could be fifth degree assault harm. I mean, raise your hand if you've ever seen cases that are charged by law enforcement where they call it fifth degree domestic assault. Is there a fifth degree domestic assault in Minnesota? I see you're all shaking your heads. No, that's not a thing under the law. There's fifth degree assault. There's domestic assault. They're not the same thing. But if you have that, you might still be able to connect the dots and say, yep, this still triggers a firearms ban. Fourth degree criminal damage to property pending on the victim relationship. I put this one up there because this is one I've actually litigated. I had an applicant from Wisconsin who had been charged with domestic battery against her boyfriend, and she was convicted of fourth degree criminal damage to property. She then comes to one of the cities I represent and says, hey, I want a gun permit. And they say, we don't think so, but we'll ask Joe. And I say, I don't think so. Because I went back through the elements. I said, you were charged with a misdemeanor. You were convicted of it. It involved force because damage to property by definition of the word damage involves force. And it was against a partner because it was his property. So it met the definition. And so she was denied. She appealed. Remember my judge joke? We went to court and I told the city, I'm like, I don't know what the judge is going to say on this. This is my interpretation. I'm pretty confident I can make the argument, but maybe the judge won't agree. Oh, kind of a big deal. I'm pretty good at what I do because the judge agreed. So I just give these as examples of these are cases that will come up. And the tips that I would give anybody, well, we'll talk about the tips in a minute, but what I would tell is you have to know, you have to have a flag. And as domestic violence advocates, go all the way back. Why is it important for you to know? Because you're the ones that are going to get signed to cases that involve intimate partner violence. Hey, Ellie, is it intimate partner violence? Is that the same thing as interpersonal violence? Because I've heard it used both ways.
No, it's not. Interpersonal is more broad.
Got it. That's good to know. I've always said intimate partner because that's what I've learned it is, but I've
Mhm.
also heard other people use it, and I guess I don't use the second one. So that's good for me to know. Hey, I learned something. Um, you guys are the ones that are getting those cases assigned. So you're going to be able to say, hey, this is charged as a blank. If it ultimately doesn't end up as a domestic assault, those are conversations you can have with the prosecutor or the victims or law enforcement about whether or not some other mitigating consequence, like a firearms ban, can still be maintained if there's a different conviction, like a disorderly conduct or a criminal damage to property. So remember, state and federal law, that's federal law, misdemeanor crime and domestic violence. If it's there, it's a lifetime ban, period. State law, little bit different. State law says a person is prohibited from possessing a gun if they're convicted of any domestic assault under Minnesota law, any domestic assault under Minnesota law using a firearm, convicted of assault, domestic assault, or similar laws elsewhere. So if you've got battery from Wisconsin, for instance, that would probably qualify as assault under Minnesota law based on the definitions. For 3 years. So remember, state, federal law, lifetime ban. State law, if it's not a misdemeanor crime of domestic violence, it's only a ban for 3 years, so long as there's no new violations. Now, I put on there federal prohibitions may still apply because I get worried because lawyers really like to say, well, we got the rule and here's the exception and that's all there is. And I say, not so fast. You need to know that there might still be a federal prohibition. You should analyze it from both standpoints. You should say, is this a state ban? Is this a federal ban? Because I don't really care what the reason is. If there's a ban, let's make sure it's enforced. So the tip for both of it is if you're a victim's advocate and you're looking and you want to know, is there any potential firearms issues related to this? You should know, number one, is the original charge domestic or domestic related? If it's not on its face a misdemeanor crime of domestic violence, is there another reason or basis to deny that person from possessing a gun? Now, this is a little different for you because this question will come up to law enforcement related to permits to purchase. But you may still be able to help educate your prosecutor when you say, hey, disorderly conduct, brawling and fighting as a conviction from a domestic will trigger a firearms ban federally, but disorderly conduct, noisy, offensive, boisterous behavior will not. That's something you can help them educate. Those are good details for you to keep in mind. And it's usually going to be tipped off to you because you're assigned to those intimate partner violence cases. Let's talk about protective orders. How am I doing on time? Oh, so good. All right. State law, starting out of order this time. State law, prohibition authority. The following persons shall be entitled to possess ammunition, shall not be entitled to possess ammunition if they are subject to an order for protection under 260C.201 or 518B.01. So child abuse orders or orders for protection. So there's 3 steps. If you have one of these orders in place and you want to know, is that person prohibited from possessing a gun? You should ask, number 1, make sure the order has been granted after the respondent. We all know what the respondent is. That's the person you're trying to get an order against. You're trying to restrict John Jackass from having contact. John Jackass is the subject party. So you look and say, was the order granted after he had notice and a hearing, or opportunity for a hearing, I should say. Now, built in there, what kind of order doesn't that cover? Yeah, you all said ex parte hearings, ex parte orders. I shouldn't say hearings, ex parte orders, right? So if there's an ex parte order, does that automatically restrict them from possessing firearms? No, it does not, because Minnesota law requires those 2 orders are in effect. It triggers a gun ban if there's been granted after the person received notice, so they got served, and had a chance for a hearing. Number 2, the order has to make specific restraints or prohibit the subject party from certain conduct. We all know what this is: shall not harass, abuse, etc. All of those things has to make those restrictions, and it has to find that the person is a credible threat. So what that means is it has to say you are restrained from harassing, and also we find that you're a threat to this person. If it makes those 3 things, if it has those 3 elements, it is going to trigger a firearms ban. Now, if you are a legal nerd and you follow the Supreme Court's case laws and jurisprudence that's come out, you'll know that last June, there's a case called the United States v. Rahimi. It's worth a read if you care. It's like 161 pages, but it's worth a read because it talks about why order for protection laws that dispossess people of the ability to possess firearms are constitutional. which should be a really big deal for you all because we just went through some firearms changes with some cases even older than that that changed dramatically how laws are enforced. This was a good one. This was a law that was upheld, and it gives us hope on the ERPO side of things as to whether those laws will be found constitutional. They probably will. So, really good thing to pay attention. At the federal level, 18 USC 922 G8, this was the law that was challenged in US v. Rahimi. And it basically said person subject to a court order, like an OFP, they can't possess the general requirements. Does these look familiar? Pretty much the same. Did the person have actual notice of the hearing where they served and an opportunity to participate? Does it restrain the person from certain conduct, harassing, stalking, threatening? And does it find that they're a credible threat? Those are in place, yes, federally and at the state level. It triggers a ban. Now you might be saying, well, why, what are the difference between the two? They're largely the same, but the differences come in terms of who is covered by these. Not a big difference, in my opinion. I wouldn't get too hung up on them. It's just two different sets of law. And in many ways, one of the reasons I tell people state and federal law isn't that inconsistent is because state law is often modeled after federal law on these issues. Very similar in a lot of ways. This is there. I preempted myself. This is the federal definition of intimate partner is a little bit tighter. That's the part. So, state law tip: orders for protection and child abuse orders issued after hearing. If you have that, if you can see that they're served, if you know that the person had a hearing and the order went into effect, they're likely prohibited. You're pretty good ground on that because the orders are template. The judges can fill in certain parts, but there's certain boxes that must be checked, which will trigger this. Um, I will tell you, remember my thing about judges, they get to say what the law is. There is a certain elected judge that I sometimes appear in front of who will handwrite in on these orders. Brace yourself. This order does not trigger a firearms ban. He just writes that in. And then law enforcement says, we got this order. I say, well, he's wrong. Because federal law says if it has all the other stuff, it's a ban. So he can write whatever he wants on there. But really important to know that stuff because you're going to see some judges, particularly elected ones, do some crazy stuff sometimes. So other orders. Plain language of the statute only covers orders for protection and child abuse orders. That's all under state law. Any other order, domestic abuse no contact order, HRO, those aren't necessarily covered, although they might under federal, but under state, it's got to be one of those two. I put in there the danger to self or others application is because sometimes law enforcement will run a background check and they will say, well, we don't have an order for protection in place, but the guy's got a Danko in place. Is he prohibited? And thankfully, our laws were changed last year as well that said now law enforcement can deny a permit to purchase, basically saying this person is ineligible because they're a danger to themselves or others by virtue of a domestic abuse no contact order being in effect. So your federal law tip is right on point with that. You don't have an OFP, you don't have a child abuse order, but you've got an active harassment restraining order or an active DANCO. Do those meet the elements for a federal prohibition? And how would you establish that? Well, law enforcement, I'd say go pull that order, see who is involved. Does it involve an intimate partner? Does it have the certain findings in there? It's tough to say, but yeah, I've seen HROs that look a lot like an OFP for some reason. Some counties do them that way. DANCOs, technically, the DANCOs are held at the criminal hearing. So there's an opportunity to participate. There's a notice for it. And then if the judge makes sure those specific findings are in there, yeah, you could make an argument that that's a federal ban. So let's talk a little bit about extreme risk protection orders. I want to make sure we get done in time so you all have time to ask questions. Minnesota's law 6247171. It's a red flag law. It went into effect January of 2024. So it's just over a year at this point. It's a civil order that prohibits persons from possessing firearms during the order, and it authorizes the removal of firearms from prohibited persons. It can be ordered on an emergency basis or after a hearing. And this one we'll come back to at the end. But once it's in effect, county attorneys must be notified that the order was granted. So why ERPOs? Well, remember our prohibitions. Those only trigger if someone's asking to buy a gun. They want a permit to buy a gun. So a federal prohibition that says a domestic abuser can't have a gun, it's only really helpful if they basically say, can I buy a gun? ERPOs are orders that allow law enforcement to go confiscate a gun, to literally go take the gun from the person, provided that certain findings are made. So it's helpful because in a really scary situation, you don't need to wait for a criminal charge or some other court process to take effect. You can go get this order and it can be granted really quickly. Potential at-risk persons, who are we talking about? We're talking about mentally ill, domestic abusers, violent persons, suicidal, or an acute crisis. Is it constitutional? This one gets asked a lot. There's a lot of sheriffs who ask this question sometimes. And for all of you who are maybe in greater Minnesota and you work directly with the sheriff, you are probably going to get some pushback on whether or not they're ever going to use ERPOs, because there's this belief that it's unconstitutional. Hey, look at that. US v. Rahimi. Supreme Court held in an 8-1 decision that the law related to orders for protection was constitutional. And I remember, what's an order of protection? It's a civil order that makes findings about the person being a risk and dispossesses them from a firearm. Sounds a lot like an ERPO, right? It's a civil order, at-risk persons, keeps gun from them. So it's very likely that if this Minnesota's ERPO law was challenged on a constitutional basis, it wouldn't be overturned because we've got this Supreme Court decision. They don't decide anything on an 8-1 basis. Nothing. Everything's 5-4, 6-3, 8-1. Pretty good that they're going to uphold this down the road. And that's specific. When a restraining order contains a finding that the person poses a credible threat, they can, consistent with the Second Amendment, be banned from possessing firearms. That's pretty good law to have in defense of an ERPO statute. So the stats from last year, year in total was 135 ERPO cases filed. I myself, I think I've done 19 at this point, 18, 19, something like that. So I've done quite a few of them. Of those, 71% were filed by law enforcement. Hopefully your domestic violence advocate ears are perking up right now. You're saying, why would so many of them be filed by law enforcement? Well, ask yourself, who calls? Who responds to calls for suicidal persons? Who responds to calls for domestic abuse? Who gathers evidence related to violent people and possession of firearms? Yeah, law enforcement does. Law enforcement goes out. Law enforcement gets this information, and they're on scene making a determination about whether or not more action like an ERPO needs to be taken. 95% of emergency ERPOs were approved. 78% of long-term ERPOs were also approved. The type of threat that we're talking about when an extreme risk protection order is sought and granted, 36% is domestic violence related. That's 1/3. 58% is suicide threats, 41% mental health, 40% substance abuse, 17% law enforcement. If you're doing the math, you're like, those numbers don't add up. Scary alert. Some people have all of them. Some people have a mix of some of them. So some of these people have threatening to law enforcement, threatening to spouse, partner, suicide threats, mental health, and substance abuse. The average amount of was 3 firearms per person seized, and in one case, 47. The highest I've seen is 17. There's a lot of guns out there. And when people are risk to themselves or others, there's a lot of steps that have to be taken to make sure that they don't get to use those firearms. So, examples of cases, ERPOs, that were granted. Respondents who had a stockpile of weapons, pictures of dead children, police, people of color on his computer, along with terrorism plans outlining violent beliefs and attacks. Talk about that one in a minute. Threatened suicide during an altercation with his girlfriend. These are all different people. Threatened to kill law enforcement during a DUI traffic stop. Threatened to kill his ex-girlfriend. This person believed he was hearing voices while threatening his wife and had access to a gun. Someone laid down on the train tracks, was hit by a train in a suicide attempt after attempting to buy a gun in South Dakota. This college student believed he was Slim Shady and had a relationship with an imaginary girl. He threatened to shoot his mother. All of those pretty wide, a lot of mental health, a lot of violence, a lot of threats, things like that. It's exactly what you thought. So let's talk about case studies. Let's talk about a couple case examples. In March of 2024, officers for a city I worked for were responding to the call of a person. She was distraught, said, my partner, father of my children, he's becoming mentally unstable. I'm finding all this stuff on his computer. It's really weirded me out. And he's bought a bunch of guns recently. It's really scaring me. Officers show up, they document the scene, they make sure she's okay, they make sure the kids are okay, they talk to the guy, they take photos of the scene, including where the guns are located, the conditions of the home, screenshots of the computer stuff. They didn't access it. The caller, she's like, here you go, take a look. There's pictures of all this stuff, along with their other observations around the house. They wrote these documents into police reports. And if you're a victim, domestic violence advocate, I'm telling you this part, it's documented in police reports so you can start getting tuned to those cases where you may want to call the city attorney and say, this is a domestic case that happened. Pause. This wasn't. But when you get cases like this where you've got a domestic violence case and you're seeing some concerning things, if it's in the police report, you may want to point that out to your prosecutor or your city attorney or your police chief and say, do we want to, is there something somebody wants to take an ERPO on? And your city attorney may be your best bet because you'll have the most easy and frequent access to them. But so what did they find? These are just some of the pictures. On the left-hand side, my left-hand side at least, the firearms, they were not stacked like that. They were laid out like that when law enforcement was gathering them. And where did they find them? Well, in the second picture along the wall next to the cribs, they were stacked up. So somewhat concerning, pretty close access to the kids. What do you see in this picture? Yeah, yeah, it's I've heard of tinfoil hats. I have not heard of tinfoil house. This floor to ceiling tinfoil. And why is that concerning for the younger people in the group who maybe haven't heard the phrase tinfoil hat, who don't know what paranoia means? This is paranoid delusional behavior. This is somebody who believes that he needs to insulate himself from the outside world. So pretty scary observations. These I am not going to read. I'm just going to leave them up shortly, but this person had what I would describe as a manifesto, documenting why rape should be legal, documenting why different races were inferior, documenting all the things he believed, and then very grotesque pictures of, I'll just describe it as dead children, dead law enforcement officers, dead persons of color, etc. Videos, pictures, all that. And he had it saved, which I don't know if you guys can see it in the picture with the thumbnails, but in the green bar there, can't quite see it, but you're all going to lean in close right now. And it looks like it says errorism plans. He named this terrorism plans. This was the drive where he had all his plans listed. So just, you're looking at this, you're a law enforcement officer, you got guns everywhere, you got paranoid delusional behavior, you got a guy who believes he has terrorism plans. What do you do? Well, let's talk about what the police found. Specifically, they found 7 guns in the house, stored unsecurely, including near children's cribs. They found bins of used and unused ammo, stockpiled water, food, tinfoiled walls. His CPAP machine was tinfoiled. Pictures, computers with writings, etc. So putting a pause on that, what do you do? You're law enforcement. Well, if you're aware of this law, you got to know who can petition for an ERPO. Could be your police chief or their designee, your county attorney, your city attorney, your spouse's former spouse's parents, children, people residing with the respondent, people in a significant romantic or sexual relationship, or guardians. So kind of 2 groups, right? People who know about, people who are in the best position to know who's at risk. So your victims in those domestic cases, those people who are spouses or former spouses, parents or children, people who are living in the home with them, or people who receive information from that. Law enforcement, cities, counties, attorneys, those are the people that are going to get that information. Those are the 2 groups that can apply for this order. Where can they apply? This one gets more important in the bigger geographic but smaller population areas. You can apply for a petition or an ERPO in the county of residence of the respondent, or if the court denies your request to do it via remote, via Zoom, the county or residence or office of the petitioner. So you can imagine a circumstance where someone requests an ERPO and they say, I want to do it on remote, and they say, no, you got to do it in person. Well, then you can refile it in your own county of residence. Just kind of a little tip there for your victims who may pursue orders on their own. Emergency ERPOs. must allege that the person poses a significant danger of bodily harm or significant risk of suicide, and it's immediate and present. So these are those cases where somebody's got a gun, somebody's making threats. That's kind of the nuts and the intersection that you're looking for. When that happens, a judge can grant an ERPO on an emergency basis. It's in effect for up to 14 days, and you have to have a hearing. Meanwhile, pending that hearing, the court has to give law enforcement a search warrant to go take possession of all firearms as soon as practicable. Typically, the safest way for this to happen is when there's a crime or a mental health hold. Person is taken off scene, law enforcement has a warrant, they can now go seize the guns. That's the safest way for this to happen. You can also file an affidavit for alternate service if the respondent is unable to be served. That's part of the process. That's more for law enforcement to know how to do. But if you can't find the person to serve, this gives you the opportunity to do it alternatively, which is a wrinkle in the OFP world, right? Because you get an OFP and you want to make sure the person gets served. You want them to be served personally so that if they violate it, they can be what? Prosecuted. Exactly. So if they're prosecuted, it have to show that they know the order's in effect. A little different in ERPOs though, because if they're not, even if they don't get personally served, the court allows the order to take effect to the point where they can take weapons, even if you do it like by publication, for instance. So just a little bit of a wrinkle that it's important to pay attention to. At the hearing, so we've got our emergency ERPO at the hearing, the petitioner has to prove by clear and convincing evidence that the person is a significant danger to others or significant risk of suicide by possessing a firearm. The hearing can be contested or the person can agree to the order. I say that because that has happened frequently. Statutes require hearings to be held within 14 days of the original petition. I will tell you, some counties have their own practice. It's really important to pay attention to that. Because in some counties you'll get your ERPO, get your emergency ERPO, the court scheduled a hearing. I show up, I got my suit on, I got my stuff ready to go, and the judge says, Mr. Respondent, are you agreeing to the order? And he says, I am not. And the judge says, great, we'll get you a hearing date. I don't know that that qualifies as legal under the statute, but some judges are doing it. Hennepin County is doing it that way, I know. So something to be mindful of for sure. That those hearings may or may not happen at that first attempt. At the hearing, the court has to consider essentially four areas or main areas of concern. Number one, a history of threats of violence, use of force against another person, violations of any court orders, or whether they're subject to any court orders, prior arrests for violent felony offenses, convictions or arrests for misdemeanor offenses, including stalking, domestic assault, convictions for cruelty to animals or using a weapon recklessly, unlawfully, etc., and then suicide attempts and mental illness. The court may also subpoena peace officers to give testimony in a written or sworn statement, and then consider any other evidence that bears on whether the person poses a danger to others. So kind of the main areas to recap: a history of threats, court orders or violations, arrests or convictions for violent crimes, suicide attempts, and then I put anything else because the court has that. The statute says the court can consider this stuff. And as a lawyer who wants to make sure we follow the rules of evidence in the Constitution, it's kind of an end around. We don't have to worry so much about hearsay. At least the judges I've seen aren't, because they know they got statutory authority to consider it. So the anything else stuff, you guys get a lot of information. I got victims advocates who will come to court with me and they'll say, hey, let me show you what she received. She reported it to law enforcement last night. Look what he sent her. And I'm talking about social media stuff. If there's social media stuff out there, I've had several cases that were proven, at least in part, based on social media threats. Things that are out there that might not be in a court record or a criminal history or in a police report. Something that's going to show up elsewhere. And that's the part where DV advocates can be really key, because if your victim, your client is talking to you about it and saying, he's got stuff that he's sending me online, make records of that. Get that to law enforcement. Get that to your city attorney, because that may trigger us to go do something else for sure. So back to our case study. Surprise, law enforcement said we got to get an emergency ERPO. It was granted. A hearing was then held. We scheduled it within 14 days. As you can imagine, that talented lawyer Presented all that information. I said, Judge, this guy has violent paranoia. He's stockpiling food and provisions. He's got disturbing imagery on his computers, to say the least, that have violent threats. He's got weapons accessible throughout the home, especially to his children. He's got terrorism plans. He's got a previous domestic assault arrest. We put all of those into evidence. It's 35 exhibits. So here you go, Judge. Take a look. There were two officer witnesses, including the petitioner and the detective who assisted in the search warrant execution. 3.5 hour hearing, which outside of jury trial, that is easily the longest hearing I've ever had on an issue. Just trials take the longest. Everything else is more or less quick, an hour or less. This one was a pretty long hearing. Judge granted the ERPO, citing all of those things I pointed out: the paranoia, the access to weapons, the violent delusions, the significant danger to other persons when possessing a gun. The order was issued for 1 year, and it required an immediate transfer of all weapons, even those not seized at the initial search, and said he can't purchase weapons. So, update. When I used to watch Unsolved Mysteries, and there'd be somebody missing, I always loved at the end when they'd go, update. Does that resonate with anyone? Raise your hand if you do. Forget it. They'd give you an update. Here's my update on this one. Hey, Kate Bly. All right. This original hearing, the original order was granted April 17th, 2024. April 17th, granted for 1 year, which means when did it expire? Today. I got a suit on because I'm a lazy lawyer and I only wear a suit when I go to court. So guess where I was for court this morning? This case. And we still don't know what the judge, we don't know what the judge is going to do on it. We went back to court. We talked about it. We said, the concerns are still there. I don't know how you age out by itself, just time passing. That doesn't make us feel better about somebody who has plans and pretty violent beliefs and a history of arrests, at least. So we applied for an extension and we had a hearing, and the judge will have to decide if time passing, and I say this part, is time passing enough for risks to mitigate or abate. So another way to saying is time passing enough to make the risk go away. And I would argue it doesn't. In some cases, maybe, but in many cases, how does that get better? How does someone who's got a tinfoil house and firearms, how is that better? I don't know. I don't know. So that's the argument. I worry about people. I want them to be healthy. I want them to have the privacy they want, to have whatever beliefs they want. But when it spills over into threats and violence and paranoia, that's where we have to act. And so shoot me an email in a few weeks and maybe I'll know if we got that extension or not. So case study 2. Let's talk about case study 2, because this is far more common, the type of ERPOs we're seeing. Law enforcement receives a report from a person stating they received a photo from their ex-boyfriend who was holding a gun to his head, threatening to come over and commit suicide. Law enforcement found the ex-boyfriend. Law enforcement petitions for an emergency ERPO, and the judge denied it and said it wasn't enough. What are the 3 sources of law? Constitution, state law. What a judge says. Judge said that's not enough. I disagreed with the judge, but okay. So then a hearing was scheduled. And at the hearing, I got to fix the slide because it says petitioner's attorney. That was me. I could just say Joe presented the evidence to the person, the respondent, said, hey, this is what we're going to seek. This is what we're going to show you. I explained he had the right to have the hearing or just waive and agree to it. And I kind of said, do you really want to go through that? This sounds like the worst night ever. And he said, nope, I do not. I agree. I don't want the gun. Take it from me. So he agreed to it. And then at a 6-month review, same conversation. He said, hey, I'm good with this. I don't need it again. So that's far more common. I think people think, because of my case study 1, I certainly thought these ERPOs are going to be pretty contested. And I've contested, I would say a majority of them, they've been contested, but a lot of them have not been. So just something to keep in mind as to how they look and what some options are when they go to court. So your ERPO is granted. What now? Well, transfer and confiscation happens. So think through it. Domestic violence arrest. Victim says he's got guns right there. Law enforcement says, I'm going to go ahead and apply for an emergency ERPO, which is how I'd recommend it, by the way. If I don't say it now or at the end, or I'll say it now, I'd be very cautious about telling a victim of violence to then go seek to take away the guns. That's something that you need to make sure your law enforcement is going to take the lead on. I think it's the safest way to do it. It's certainly less safe for a victim to do it, just in my experience. So you get that ERPO on scene, the guy's arrested, an officer gets a search warrant, they can now confiscate. The court has to give them a search warrant, and then they can go ahead and execute that search warrant to get all the items. Non-emergency ERPO, transfer as soon as reasonably practical, but 24 hours or less. Um, and then they can transfer it either to a federally licensed firearm dealer or to law enforcement, either on a temporary or permanent basis. If they transfer it to a firearms licensed or federally licensed firearms dealer, they can charge fees. But if they transfer it to law enforcement, they can't charge fees. And if they sell it to law enforcement, it has to be at fair market value. And then antiques, you got a musket loader. Is that the right term? Somebody's going to correct me on that. They can transfer it to a relative who does not reside with the respondent if that relative can also lawfully possess. And then obviously if there's a search warrant executed, this slide is mostly for law enforcement, but they have to itemize what they took, where it's going to be stored, and then leave the receipt. So extreme risk protection orders, what I have learned and what questions I still have, even after doing this for more than a year now. Law enforcement has to decide their agency's approach. And I call that the if not you, then who rule. If law enforcement is getting these threats and investigating crimes and investigating cases, and they have the information and they got the guys with the badges and the guns and the arrest powers, and they're seeing it, and they're not going to step forward and say, let's go get an ERPO to make sure this domestic abuser or this person who's doing whatever crime or having whatever breakdown or risky behavior so that they can't possess a gun. If it's not going to be them, I don't know who it's going to be. Because remember back to my case study one, the start of that case was a call. Somebody really concerned, not domestic, but it was a domestic relationship. And that person was really concerned about the state of her partner. Well, guess who flipped before the hearing and decided she didn't want to testify and had changed her mind? Does it start to sound familiar? So if not law enforcement, I don't know that we can put victims or family in the position of having to carry this forward. So law enforcement has to decide we're either in or out on this. And if we're in, be prepared because you're going to have a lot of cases that come through that might meet these criteria. And I don't endorse the law. I don't detract from the law. I say this is what the law is. And if we don't take action, sooner or later, number one, something bad may happen. And number two, people will have questions. Why didn't you do this? So something really important. So have those conversations with your prosecutors and law enforcement. I certainly encourage anybody in a domestic violence advocacy organization to reach out to law enforcement, make contact, not just about this issue, but just big picture. It cannot hurt you in your work on behalf of victims and survivors to make sure that you have good working relationships with law enforcement. It cannot hurt you, especially when it comes to something specific about ERPOs. Number two, how are threats identified and orders and warrants safely enforced? The second piece is a law enforcement question. You have your order, how are you going to serve it so that we're not having a standoff and we're not having some type of bad interaction? The first part is how are threats identified? This is where you can help. This is where you can be real honest and candid and disclose what you can when someone says, hey, there's a firearm in the house and it's concerning me. Those are things that you can make known to law enforcement or your prosecutor because they may be able to take those next steps. Who is handling your ERPOs? This one, again, probably more for law enforcement, but something you guys to think about. Is it going to be your city attorney? When you go to court on a misdemeanor calendar and your city attorney's prosecuting the domestic crime, who is going to have that? Who's going to take it forward? Because that may be the person sitting in court with you. And you may be able to say, hey, Mrs. Prosecutor, are you the one who handles the ERPOs for your city? And they're going to say, what's an ERPO? And you're going to say, I just saw this great presentation and I can tell you all about it, but also, are you doing them? Because you want to know that. Because remember back to the start, the timelines, you get an emergency ERPO. Let's say it's a domestic violence arrest and they also seek an ERPO that day. The criminal case in most counties, well, they're going to go to jail that night, but then they're going to get an arraignment or a pretrial date down the road. And then with the ERPO, it's 14 days. So you really need to know, you want to know who your prosecutor is, but you want to know who's going to come to court on these. if we get one, we have to act fast. And lawyers don't act fast on much. So it's a really good big picture conversation. Domestic violence advocates can help that by talking to their attorneys, by talking to their law enforcement colleagues and saying, do you know who's doing it? If you have one, who's going to be the lawyer that helps you with it? Doesn't have to be a lawyer, but that's the way it's looking more and more, is that lawyers are going to be the ones doing it. And then finally, what's the end game? Guys, that case study one really concerns me. It just, you don't know what the answer is. You don't know what it's going to look like. You don't know what would fix somebody who has such delusional beliefs. There are certain people with domestic violence records that I've done ERPOs on, and I look and say, I don't know what the fix is going to be. I'm not sure if they don't meet a criteria for mental health treatment, or they don't have a chemical use problem that we can address with treatment. I don't know what makes people not a threat, but we have a tool to reduce the threat by taking away the weapon. But sooner or later, the weapon may have to go back, and what then? So thinking through that, remember back all the way to my first slide where it talked about what's the end game? The county attorney has to be notified. As best as I can gather, that's the legislature's tip of the cap to or nod to county attorneys saying, hey, all right, somebody gets an ERPO because someone's has mental illness. Maybe you want to take up a civil commitment. That's the only part I can figure out, is that they want to make sure that somebody who has a different tool can also start applying pressure. So that's, I think, what I got. Put this up here. This, again, is more for law enforcement, but it's a training I'm doing in Bloomington and Duluth. I can scan it on the QR code if you want to sign up and go. I think this one there is a fee, so just FYI, y'all just got a big chunk of it for free too. So, and then that is the most popular kid in 7th grade. So put that on there. Questions. Let's see.
Yes, we have one question in the Q&A. I'm confused about the subpoena to law enforcement. The petitioner does not have to bring the witnesses.
Subpoena to law enforcement. I guess I don't know. Yeah, I mean, the petitioner has to prove their case. So the petitioner, if it's, city of whatever, city of Minneapolis, will say, they would have to go ahead and prove their case. So they'd have to probably bring their law enforcement witness. If they didn't have a law enforcement witness, they would have to probably bring whomever else it was. There's kind of an argument that I might make, that would say, I think technically, because the court is required to receive all that information, a criminal history, etc. Is there an argument I could make if I had to say, hey, judge, I e-filed these as exhibits. You have to consider them. Go ahead and consider them without testimony, possibly. Back in my case study one, remember the girlfriend was there and saying, I'm terrified or I'm worried, and etc. And then she didn't want to come to court. I had to make a decision. I could subpoena her, but I didn't. I used my law enforcement witnesses who observed it. All right.
And then Rachel, you can speak if you.
Yeah, sorry, I didn't ask a clear question. Your slide said that the court would subpoena law enforcement.
Yeah, that's what the statute says. It says they can subpoena law enforcement. I guess I'll look at the statute. I don't remember exactly I wouldn't rely on that as far as practice. That may be language that's in the statute. I'm almost sure it is, but I wouldn't rely on your court to be subpoenaing anybody, which is all the more reason of who's going to represent the petitioner. It's petitioner's job to bring it forward.
Thank you.
Let's just hold on. Now I'm on my phone looking. I'm going to look. We'll find it. But yeah, I wouldn't rely on that. I've never done it that way. None of my agencies have. I think the court technically, one of the early trainings that I did was with a retired judge, Judge Mary Yunker. She's a firecracker. I like her. But she asked the question. She said on that exact point, is the court supposed to be doing its own fact finding? I don't know. I know I don't think so, but I know why people might say that. And it's to your point about, is the court subpoenaing people? Maybe. I don't think it's likely. I wouldn't rely on that. I'd make sure you have that conversation with the petitioner and saying, who's going to bring this forward? Rachel also asked, what about a plea to obstructing in a domestic assault case? I don't know. Walk through it. It's a misdemeanor. I don't know that obstructing meets it, because it's technically not going to be ever against a a victim, the right victim. Obstructing is usually interfering with law enforcement. So by its elements, it's probably not ever going to meet the terms under a federal ban, and it certainly wouldn't be under state ban. Let's see. Can police take guns right then and there on the scene? Who knows the answer to that? It's the most lawyer answer I got. Yes, but, or yes, if. Yes, if you're investigating a crime and a weapon is used in the crime, well, number one, it's going to be seized as potential evidence. Number two, if you are on scene, you make an arrest, you get an ERPO, they give you a search warrant. And yeah, that can happen pretty quick. That's the whole point of why they have it written this way. Yeah, then they can seize those weapons. Now, is it right on scene? No, but is it within a half hour? Probably. Yeah. It can happen super quick, which is why that intersection of domestic violence and ERPOs is really important to be aware of. I do not want anyone going out and telling all of their victims, we are also going to get an ERPO on your behalf. Early on in the trainings, people thought this might be a new version of an OFP. And I have a lot of concerns about backlash toward victims who are already the ones who are going to be blamed for calling the police, saying he hurt me. And also, I'm going to take his guns, because guys who hurt their partners who also have guns tend to love their guns. I just don't know that that's the right approach. It's more you can know when something's happening, how to also give that information to law enforcement or the county or city attorney to make sure that people who abuse their partners are not also having weapons still in their possession once they're released. Let's see. ERPO does not include knives. I'm just going to answer that question from Amanda was, would ERPO include knives as well? It does not. And part of the reason from that is what we know about the data with related to firearms, with related to suicide, how violence is perpetrated. It's firearms. It's firearms, 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 guns, guns, guns. That's how it's done. That's the most likely. Knives, you get into a whole nother thing. What kind of knife? What type of knife? Is it a kitchen knife? What if somebody uses a hunting knife in their kit? I mean, there'd be no way to enforce that. Yeah. Oh, hey, Amanda, this is why, hey, listen, Ellie, we should make this a big one so we can just talk, because I don't like talking to myself in my office.
You can present at new laws
I'll present at new
next year.
laws. Is it in person?
Yeah, it's 5 times in person, 1 time virtually. You can travel around the state with us.
That seems like a lot.
It is
Anyways,
a lot.
Amanda says, okay, some offenders are knife collectors and pretty scary. Absolutely. I get it. I mean, what this statute is, what ERPOs are, what gun laws are, they are risk mitigation tools. And obviously we can't mitigate every risk, but there are things that we can do to mitigate the big ones that we know about. The gun laws, guns are the biggest tool used. So that's what this law certainly gets at. Yeah, let's see. Rachel, you had a question. Is there a requirement for attorneys to have CLEs with updates about gun laws? No, there's not. There are standard credits. There are credits related to ethics and bias, credits related to mental health and substance use. And you have to report every 3 years. It's my year to report, so I got a whole bunch to do. But no, there is not. And the reason how we got there is lawyers are presumed competent to do just about anything once they pass the bar. And so whether they know, somebody's jumping in as your city attorney and has no concept of what it means to talk to a survivor of domestic violence, has no idea what 611A requires and doesn't require, has no idea of the prohibitions on firearms or the cases or collateral consequences of the human beings they're dealing with. It's unfortunate. It's partly why I jumped in on this, because this is a big topic to me. It's important to get it right. And I think I can help law enforcement get it right. And that's part of this, is helping you guys get it right so you can help law enforcement get it right, and we can have safer outcomes.